Hi, my name's Marty Frescona, an entertainment attorney at Frescona Entertainment Law. So I decided a few months ago to produce some impromptu videos for several of my clients who needed some basic knowledge on various entertainment law topics. Now, oddly enough, these videos took off as it became apparent many in the industry were looking for some basic legal knowledge on important yet undiscussed topics, but without being charged hefty legal fees. Now, because of this interest, I plan on keeping this web series alive, and today we'll be discussing a topic which doesn't get much attention. Now, believe me, this is one of the most important money-making aspects for bands today. The topic, why your band must have a registered trademark. Now, performing artists essentially have two intellectual property weapons, copyrights and trademarks. It appears everyone has some basic knowledge about copyright, so I'm going to stay away from this explanation. But if you have questions, feel free to contact me. Now, the other IP weapon in making money for bands is the trademark. This is a highly relevant topic for entertainment practitioners and labels, but unfamiliar to a majority of bands. Now, let me tell you why that is. First, if you own your trademark, you immediately have leverage over labels, promoters, managers, and agents. They don't want you to know this. Now, secondly, people really don't know how to maximize their income stream by putting their trademark to use. I'm about to teach you how. Now, let's just start off with a working example. Now, one of the most sizable income streams for indie artists today has become concert posters and promotional material. Now, traditionally, bands will hire a graphic designer to construct eye-catching concert posters, and within those posters, the group name is obviously showcased. Now, current trends show that graphic designers will sell their creations on the web, concert poster websites, or art galleries. Now, for bands, they essentially just gave away a substantial chunk of their income. Essentially, the designer is making money off the group's trademark, or mark as I'll refer to it, and the band isn't. Let's assume for a minute that Coldplay doesn't own their trademark. That means anyone could print Coldplay t-shirts, concert posters, apparel, and so on. However, since Coldplay probably does own their trademark, they have the ability to license the mark, meaning if anyone wants to use the mark, they must pay a licensing fee to do so. So you're going to learn 4 things in this video. Number 1, what is a trademark? Number 2, why bands need a trademark. Number 3, how to file for a trademark. And number 4, how to use your mark for control and leverage. So the million-dollar question, what is a trademark exactly? Well, a small portion of the legal definition states that a trademark is any unique symbol, design, mark, or words that distinguishes the product from others on the marketplace. Company logos and graphic designs are also capable of being registered marks. Now, the 2 words you need to latch onto in that definition, words and marks. So the Nike swoosh, for example, the word Adidas coupled with the 3 vertical stripe logo, the McDonald's golden arches, the word Google, the BMW logo, and so on. Now, large companies and brands sink substantial money into building awareness of their particular marks. Visually speaking, don't you view the Mercedes symbol as a high-quality car? Now, contrast that when you see the logo for a Suzuki Sidekick. It's not really the same reaction. So trademarks mold and manipulate the public into expecting certain levels of quality. Now, there are other marks that fall within the trademark family that you need to be loosely familiar with. Number 1 is a service mark. Now, these are marks used by a service industry for purposes of advertising. You'll see this as an SM symbol. For example, the NFL, the NBA, the Major League Baseball logos. Those are all examples of service marks. Number 2 is a certification mark. Now, these are specific words or symbols adopted by a group of companies or government agencies to denote attributes relating to the goods, the RIAA in the music industry, for example. Third, you'll have trade dress. Now, this refers to characteristics pertaining to the visual appearance of a product or its specific packaging. The classic Coca-Cola bottle, or the specific appearance of a franchise restaurant. Essentially, they own the design rights. But what we'll be focusing on is the unregistered trademark or the registered trademark. You'll see this with the symbols TM or an R with a circle in it. Now, why do bands need a trademark? There are two main reasons that I referred to earlier, control and leverage, both of which aid in increasing your creative income stream. Now, many viewers have probably read the stories on the Music Globalization blog addressing these very topics. If you haven't done so already, I would suggest going to www.musicglobalization.com to see why control and leverage are so important for bands, both indie and major. However, let me give you a quick overview. In today's do-it-yourself market, it's essential to understand the best ways to maximize your profit. When you own your trademark, you own the use of the mark. When promoters promote a show by featuring the band's name or logo, guess what? They must acquire that mark by a license. Should a label wish to release an album but you own the mark, guess what? They have to acquire a license to do so. Should someone want to put together apparel, guess what? They have to have a license to use that mark. License costs money, and the value is set by the trademark owner. Now, how do you acquire a trademark? There are two ways to acquire a trademark, both of which bring certain protections. Let me address the minimal legal requirements just to give a broad overview here. I'll also focus on filing marks in the United States first, and then I'll kind of address how to file marks abroad. Now, the first way to acquire a mark is to simply start using the mark. This is what's referred to as a common law trademark. This is shown with a TM symbol. The legal bar, so to speak, is relatively low in order to achieve a common law trademark, as the mark must be used in public in a manner that creates an association among consumers between the mark and the mark's owner. Other minor requirements demand that the mark must be continuous and not sporadically used, simply meaning you can't use the mark once over the course of a year and then pick it up 4 years later. This would be deemed sporadic. Now let me explain the good and the bad about common law trademarks. First, the good. They essentially have no cost or complications pertaining to filing. It's just a race to the marketplace to use the mark before anyone else. For example, if a band in Boston starts operating under the name Sam Adams' Favorite, and they've consistently used the mark with promotions and albums, marketing material, etc., they essentially own the rights to that name. Should another group in Boston form using a similar name, or worse, the same name, the earlier group can stop them from doing so. They have the common law right to the mark. In a legal nutshell, if you can show you were first to the market and confusion or dilution of your mark was caused because of the defendant's mark, you're likely to win. Now, the bad news. Protection is extremely limited, and you can be pigeonholed to a specific location. I'll explain more of this in a second. But the most relevant mark for bands, the way to make big money, is to acquire a federally registered trademark. To acquire a registered trademark, you need to register the mark with the USPTO. Now, registered marks are indicated by the symbol R in a circle. Now, filing is a lengthy process and best to be handled by your attorney, more specifically an intellectual property attorney or an entertainment attorney. One of the reasons to hire an attorney is in this process to assure that you file in the correct category and to assure paperwork has been adequately drafted. Now, the USPTO evaluates marks on a variety of factors, none of which I'll bore you with here today because it's boring legal terminology, but they essentially weigh their consideration based upon categories and competitors. For example, you can have the same mark operating in different industries. Delta, for example, is used as a registered trademark for air travel, but also for faucets. The USPTO would not allow two Deltas to operate in the same category. Now let's address the bad news first. A registered trademark is an expensive investment, comparatively speaking. So now the good news. Now, a registered trademark is the ultimate protection. Should the mark be accepted by the USPTO, you become the rightful owner of the mark for use in a particular category. Now, registration and acceptance also means that everyone has been given formal notice in the United States of the mark's registration and ownership. Now, the legal significance of this is quite grandioso. Anyone using your mark or similar marks which may dilute your brand are subject to some pretty serious legal allegations. You can sue for lost revenue, you can immediately issue cease and desist notices to stop using the mark, or you can sue for punitive damages and so on. Without a federally registered trademark, your control is extremely limited, nor can you file for injunctive relief or damages in federal court. Now finally, having a legally registered trademark with the USPTO is a prerequisite to having international protection. Now, because intellectual property law varies country by country, trademarks must be registered in each desired country of expansion. For example, if you own a trademark in the United States and you intend to expand that mark into, let's say, Egypt or Austria, you must file an application in each of those countries. Now, however, due to the Madrid system, which is administered by the World Intellectual Property Organization, which is also referred to as WIPO, owners of a trademark can file a single international application for trademark registration in any of the countries that are signatories to the treaty. Currently, there are 85 countries which have signed the treaty, so if you're looking to expand, it is likely one of those countries has signed. Now, let me tell you why this would be relevant. If you're a band in San Diego and all of a sudden you get attention in Finland and a label wants to pick you up in Germany, you're having some tour opportunities in Sweden, you would want to file to have trademark protection in all of those countries. Therefore, you would sign one single application with WIPO. This would also work in reverse. So let's say you're a trademark owner in Ireland. A prereq would be that you own that mark in Ireland, and if you were looking to expand into the United States, what you would do is have to have that your trademark granted in Ireland before you would file a application with the USPTO. Because indie artists dislike labels so strongly, let's give an example where we really stick it to the labels. Now let's assume U2 owns their trademark, meaning the letter/number combination U2, plus any unique symbol to identify U2. Now let's say U2 has a savvy attorney who made a sudden amendment to the recording contract where the label's right to use the trademark was retracted. Now how effective would a U2 album be on the marketplace if the label couldn't legally use the symbol U2? Better yet, how does the label even promote it? Well, they can't. The label has to put out an album, but to do so, they have to pay U2 a licensing fee every time they need to print the symbol U2. Now this may sound far-fetched, but these battles are fought every day on the legal front lines. The reason you don't hear about it is that both parties, the trademark owner and the trademark infringer, benefit when these stories stay private. For an owner, the more someone infringes upon a mark, the more they get paid. In that regard, once a story goes public, any potential infringers in the future will be made aware of this and stay the hell away from the mark. For the infringing party, once an infringed mark hits the market and sells, the higher the potential payouts and settlement amount for the owner. Now let me give you a real-world example how this all works. So about 20 years ago, an attorney from our firm began representing a small no-name band in Louisiana in the United States. Now the band was pretty much playing dingy bars and the very limited college circuit at that time, but they had a very unique name. So upon our request, they filed for a federally registered trademark. Well, it was granted. Well, a year after this, Billboard magazine ran a full-page spread about a record label that was going to be started by one of the members of the most famous boy group of all time. Now, this record label was promoting itself under a mark which they didn't own. Our client owned it. Well, a couple months later, they began to release artists, and these artists were selling all over the world. So infringements were basically popping up all over the global map. Well, they can't do this. Our client owned the federally registered trademark, so there was infringement pretty much from East Coast to West Coast and abroad. So what we were able to do was negotiate with the label, because they had infringed, to either pay a licensing fee or they would have to buy the mark outright. Now, what our client could show was damages. I mean, this label had been using a mark which they didn't own, which our stance was that it was damaging our client and diluting their brand at the time. Well, they infringed upon the mark, and all of a sudden, this group ended up getting paid just bags of money, more so than they ever could have envisioned by performing their music. Now, I began representing a client several years ago who had just come off the heels of a very successful tour in the United States. Now, the problem with that was they were promoting themselves under a mark which they didn't legally own. They were using the mark. They weren't infringing on anyone else's mark, but they did not file for the registration. Now, their popularity on this tour got the interest of several other groups within the United States who started forming copycat bands under the same name. Now, what they would do, they would contact all the venues that my client had played at. So if my client played the Viper Room in Hollywood, they would contact the Viper Room a month later and say, we're interested in playing there. Again, they were infringing upon my client's mark, so they were piggybacking on their success. The Viper Room would obviously pick up the show because they were under the impression it was my client and they had played there before. So this trend continued all over the country, therefore diluting my client's mark. Now, how they owned this mark, they could have sent cease and desist letters or sued for punitive damages. They had a lot of protection other than what they were granted at that time. Now, I'm hopeful this has armed you with a basic understanding of why trademarks are important, how to file them, and how to use them to your advantage. And you didn't even pay a single legal fee here. But if I can be of more assistance, please don't hesitate to ask. You can reach me at my firm email address, which is mff@frasconalaw.com. You can follow me on Twitter for daily tips, and that is @FrasconaMusic. You can check out my blog about international music markets, which is musicglobalization.com, or you could receive more specific knowledge about particular international markets along with a list of labels, managers, and agents in those countries with an independent book project that I worked on. You can find that at marketandpromotemusic.com. For my fellow attorneys, you can read my contribution to the recently released Entertainment Law for the General Practitioner, which was published by the American Bar Association. Or check out all my information here. You can scan the QR code to go directly to my attorney profile page.